Okay, good morning, Friday, May 9th, 2025, House Transportation. I appreciate y'all coming in before the floor this morning. This morning, we are working on the transportation bill, which is in committee of conference, and one of the issues still in the conference that's to be decided, the language that's in there for the conference that is related to legal trails that we have gotten a briefing from our ledge counsel before. And at request of the Senate, apparently also that ledge counsel Tucker Anderson has testified in there as well, or worked with Damien on this piece. And so this morning, what we're trying to find out is there's potential options within the rail within that section in the bill right now. Keep the language in there as it is written, take the language out as it is, or potentially offer a third option that would be to keep the language, but to have a effective date that would be somewhere in the future. I've heard 12 months, 18 months, 24 months. What we're trying to find out here is, again, a real quick briefing of the situation, but what those three potential options for the committee of conference might impact what's going on with the lawsuit or how the legislature decides to act. This is an education piece for the committee and trying to focus on what those three options might mean if the legislature were to take action on one of those three things. Damien, I'd turn it over to you or to Tucker. I'm not sure which order we want to go, but we want to hear from both of you and whatever your combined efforts, and help me if I didn't describe all of that correctly.
I think you got most of it. So for the record, I'm Damian Leonard from the Office of Legislative Counsel. I'm joined today by my colleague. Tucker, you want to introduce yourself or?
Sure, Tucker Anderson, Legislative Counsel.
So Tucker is our municipal law expert in-house, and then I cover transportation issues. So because this covers both town highways and the rights that a town holds, we've both been involved in this legislation. And Tucker has been involved with it for longer than I have here because he worked on it last year as well when there was a bill introduced in the House. So we can discuss, we can really start anywhere that you want. I think that the kind of key issue behind all of this is the ongoing litigation and the potential risk that's at the end of that litigation. I think they're putting aside the issue of the right to maintain the rights of way. So we've talked a little bit about that, and we can get back to that. But then the key issue is there's an ongoing litigation about what rights the municipalities in Vermont hold and whether the legislature intended in 1986 to give up the right to maintain legal trails in the same way that towns hold the right to maintain all of the other public rights of way that a town holds, class 4, 3, 2, and 1 highways. In that ongoing litigation, the landowner has alleged that the town, through that legislation, the town's rights to maintain were given up, which means that they revert to the landowner. So a property right, a right to control the property, if you follow their argument, would have reverted to the landowner. And then in order to take that property right back, under Article 2 of the Vermont Constitution and under the 5th and 14th Amendments of the US Constitution, the government needs to provide compensation to take property. So the question in this case is, if the landowner prevails, and that's an if, so it's the court's place to decide that case. I think both sides have made their strongest arguments. And I can tell you from litigating that I can never predict exactly where a judge is going to come out. But if the landowner prevails and the court finds that that property right lies with the landowner, the the language that is currently in the T-bill as passed the Senate would be granting maintenance rights to the town. And so that would actually, in effect, be taking a property right from landowners if the landowner prevails, which would mean that we would then be potentially facing what are known as inverse condemnation lawsuits. So condemnation is where the government goes out and says, we need to lay out road. And so we're going to sort of lay out where the road or the right of way goes. And then we're going to assess the value of the property rights and offer landowners compensation. If they don't like it, there is a statutory process for them to dispute the amount of the compensation and for a neutral third party to determine appropriate compensation. That can often be a time-consuming process, but it's something that we do with highway projects all the time. It is a common process. We do it with airports. We do it with air rights over airports and around airports. Railroad rights of way. So this is a common, eminent domain is common. Inverse condemnation, on the other hand, is where the landowner sues the government for compensation. And so the step one with that is a lawsuit to determine if the government has taken a property right. And then if the government loses, then you go through the process of assessing the value of that property right and determining compensation and determining whether, for example, the landowner should be able to recover attorney's fees and costs for having to sue the government. So it's potentially drawing things out. With the current case, there's one other thing that the current language may do to that case. And in the short term, this may be seen as a benefit to the municipalities, but it may just mean that we delay getting an answer on where the court feels the law stood in 1986. And so that is, right now, the case is what's called a declaratory judgment action. The parties have asked the court to declare what the law is. So the current law, which doesn't have the express mention of maintenance for legal trails in it, the town is saying, well, we think we have the right to maintain, because typically in a right of way, you have the right to maintain the right of way for the purpose for which it's been granted. The landowner is saying, no, we're a Dillon's rule state. And if it's not expressed in the statute, that means the legislature meant to take it away. And so now it's up to the court to say which side is right on that. What happens, though, when you change the underlying law that's subject to a declaratory judgment action is there's a potential that the court says the law changed. I no longer have to decide what it is because that law is no longer in front of us. It's no longer current. So then they dismiss the case for what we call mootness. Which then means that you would get to the next point where you have an inverse condemnation lawsuit where question one is, was there a property right that the landowners had before? And then question two is, if there was it taken without compensation? And then you go down the road. So what could happen with the language that's in front of you is there is the potential that the current case gets dismissed. And you're left in a position where a new case has to be filed. And then we are waiting several more years. I think the current case has been pending for something like 3 years. So you're facing multiple years of additional litigation while we wait for a final answer. And then it could be in the end that the court rules in favor of the municipalities in either event. And there's no issue here. It could be, however, that they rule in favor of the landowner, and then we have to find a way to provide compensation through our municipalities or through the state for these rights. And I can't tell you what the right to maintain is worth. I don't even know where to start on valuing that right. And I would have to, so I can't tell you what the final costs are likely to be if the plaintiff prevails and we have to pay. That's just way outside of my area of expertise, but that's basically the legal issue. The chair mentioned delaying the effective date. So with delaying the effective date, there are two issues that are there. There's the legal issue, which is with a declaratory judgment action, frequently when there's prospective change in the legislation that hasn't taken effect yet, the court will say, no, the law is still what the law was when you filed the case. We're going to decide the declaratory judgment action. So there's a chance that you get a court decision and say you delayed it a year to July 1 of 26 instead of July 1 of 25. There's a chance you get a court ruling in that time, and depending on the court ruling, you're either good to go, you've clarified maintenance rights and there's nothing you need to change, or they've ruled in favor of the landowner and you can go ahead and update the statute with condemnation language and eminent domain language to basically provide a process for municipalities to decide if they want to acquire this right, and then to go through the process of providing compensation for it. The other side of that, though, is practical issue, which has been raised, and I cannot advocate for the sides here, but I can tell you that the issue that's been raised is concern about clarity. So Tucker has his son with him, so he may have to go off screen periodically. This is what happens when session starts to run long. We all start to have childcare complications. So I'm encouraging you guys to head home. But the practical issue that's been raised is that with the lack of clarity, towns and groups they work with to maintain some of these trails are reluctant to or concerned about the possibility of going in this year. And so there is this issue of clarity. And there is definitely an argument that's been made that making it effective July 1 provides clarity going forward. It's at the risk that the court eventually rules the other way and that clarity comes at a cost. So and my job is really to highlight the legal issues for you. Unfortunately, you folks were the ones who were elected and have to balance that against the practical issues and the wishes of your constituents and municipalities. One other thing I do want to highlight is that currently the language has no intent statement in there. There is a canon of statutory construction, which argues that the legislature only adds words. Like we don't add words for no reason. And so to foreclose, I would discourage you from trying to weigh in on the case before the court, but you may wish to have language that says it's the intent of the General Assembly to clarify that municipalities have a right, not to change the statute, that municipalities have a right, if that's your belief on where the statute is and your intent on how you want to move forward. But that is something that I'm trying to figure out a way that you can move forward without influencing what's going on in the court, but also with, and so that it's just another one of these things where, as I'm assessing these arguments, there is that potential argument, well, they added the language so they knew the right wasn't there and that it had to be added. Because if the town wins the current lawsuit, theoretically, you don't need the language because the court will have ruled that the existing law already provides that right. So why would you be adding the language? If the town loses, clearly you do need the language. So then the only other argument would be what we frequently do here, which is we have folks coming in saying the law is ambiguous. can you clarify? And then we say, we're clarifying the rights here. And so I would just counsel that you may wish to consider, regardless of what you do with effective dates, if you keep the language in, you may wish to consider adding something that says it's the intent of the General Assembly to clarify that towns have a right to maintain these rights of way. I would also say that having reviewed the eminent domain language, that when that was up, so when all of this was recodified in 1986, they separated town highways out from legal trails, but they didn't necessarily reflect that in the eminent domain process, or at least not completely. So something just to flag for a future date. We can't do it in the conference committee at this point. It would be, I think, beyond the scope of what you can cover in a conference committee. You may want to go back in and clarify and clean up your eminent domain sections in the future. Just flagging that. So
I the Senate was very adamant that we hear from both of you guys. I appreciate you coming in. I appreciate where you're at. We're gonna run out of time before the floor.
Tucker,
We're gonna have to ask Tucker to take it away. And the Senate was adamant in the conference committee that we hear from both of you. So said you spent quite a bit of time there as well. So thank you for joining us.
Yeah, so I actually don't have too much more to add from, a summary level. Damien did a fantastic job highlighting all of the benefits and risks associated with moving forward with the language as it's been presented to you. The only buttressing information that I would throw out there is that this is all prospective, not retrospective. And as Damien indicated, this is not resolving the legal dispute, and adding intent language that reflects that these are prospective changes intended to clarify an ambiguity in the law is likely a very good and wise idea. And that's all that I have. Unless you have specific questions about municipal law, you want to get into the weeds on Dylan's rule,
Couch has a question.
Yeah, for either of you, just to sort of step back a little bit. These trails, these legal trails, these were at some point identified as class 4 roads, or they were, nobody added trails in the last 40 years.
So actually towns can add trails, so I can't answer whether anyone has added them. My understanding is that most legal trails are, and Tucker, feel free to jump in if you have other knowledge. My understanding is most of them are formerly class 4 roads that were reclassified as a legal trail. And it's not necessarily just in the last 40 years. There are trails cases dating back well before the 80s. They just used to be lumped in with class 4 roads, so class 4 roads and legal trails. But there are a number of spots. If you look at town highway maps for your towns, you'll see a number of spots where there's a class 4 road, and then you see the little LT for legal trail, and it goes across to a class 3 or class 4 road. And it's just where the road used to run. And at some point, the town decided it's not worth maintaining this as a road anymore, but we want to keep the right of way. And so it's the same width right of way, 3 rods, as it was when it was laid out as a town highway. Yeah.
And my next question is, and this language here is in response to the lawsuit and saying, hey, let's just define that municipalities have this authority.
That is my understanding. Tucker, do you want to speak to that?
Yeah, not necessarily responding directly to the case, but responding to the legal issue that the case is attempting to resolve, which is an ambiguity in a few statutes in Title 19.
Okay.
So,
yeah,
that's a better way of phrasing it. Yeah.
One of the risks we run because of the lawsuit is if we go forward with this, potentially the lawsuit could end up now, hey, you've taken something, compensate. That's a risk. And is that risk exist even if we didn't do this?
So the risk is potentially at some point in the future, there could be a finding that we took a property right that had been reverted to the landowners and we have to compensate. If we don't do this, the risk is that towns that continue maintaining, if there's a finding that the landowners have that right, then they could be asked to compensate because they've invaded someone's property rights. Or the flip side of that, though, is that some of these legal trails need maintenance, and so the question is who will provide that maintenance, and how do you maintain a public right of way? So there is a policy issue on one side of how do towns maintain these rights of way, particularly if they cannot get the agreement of the landowner. So I mean the plaintiffs in the case are arguing that it's the landowner's right. So you can imagine a situation where the landowner says, I don't want to maintain that. And I don't want you on my land maintaining that. So there's a question of there's a policy question of how do you maintain rights of way, these legal trails. And then the flip side is the potential financial risk if the court rules that the right lies with the landowner.
If towns are not maintaining the rights of way of these trails, legal trails, is that also a court, opportunity to say, hey, it's mine because you're not maintaining it?
I have not dug into that. Tugger, have you dug into that issue of adverse possession against the town?
No, but it is a general principle in the law that you cannot adversely possess public property interests. So this easement couldn't be adversely possessed. I think, a lateral issue there could be that property owners could assert an argument that the change in use or, downgrade from, let's say, class 4 to trail also changed the easement in its size and scope. So some of the former right-of-way could have been ceded back to the property owner, but I don't see any avenue for an adverse possession claim. It's just not possible.
And actually, our statutes provide that it maintains the same width. So I don't think there's a good argument for ceding the land. Sorry to jump in.
Representative Burton.
Sort of a side question. Isn't it true that unless a land is posted, that anybody can walk on your land? Is that? I mean, up against this somewhere. That's what I understand.
So I
Unless you tell them to stay off.
Yeah, so that's a separate issue though. So
Yeah,
this is you can't post a public right of way.
Okay.
So period. So public right of way, whether it's an easement over someone's land or owned by the town from the ground up. In most cases, these class 4 roads are likely to be easements over someone else's land that would revert if the town discontinues it. But once you have that easement, you cannot post it. You can only put gates on it if with permission of the municipality. So that's called a pent road. And so like at that point, you can't block the public from using the public right of way. There can be regulations as to the character of the use and the type of use, but that's up to the public.
So if the landowner were to prevail in this case, would that mean that the landowner owned this former public right of way, or no, it would still be a public right of way?
Yeah, so their argument is that there's this bundle of property rights that you have with your land. The biggest one is just the right to exclude people. And when you purchase an easement over land, So when the town acquired this public right of way, they acquired the right for the public to travel across the right of way, to use it for travel, and at the time for the town to maintain that right of way for public travel. And at the time, people would often agree to this very easily because the town was going to build a road out to your farm, or that went past your farm, so you could get your products to market, your kids could get to school, you could get to church, etc. All of the benefits that you get from public roads. And what happens when you switch from a class 4 to a legal trail is that all that you've done is saying that instead of this being a town highway, it's now a legal trail. The landowner's argument is that in the way we had updated the statute in 1986, one of those property rights is the right to maintain the right of way, and the right to sort of determine how and when and where maintenance is performed in the right of way. Their argument is that through the way the legislature recodified Title 19, when they separated out legal trails from class 4 roads and didn't add back in that language about maintenance, they intended to cede back the right to maintain and determine when, where, and how maintenance is performed in that right of way to the landowners while keeping the right of way otherwise for public travel. So
It's just the main.
yeah, and typically at common law, when you buy an easement, when you acquire an easement over land, it comes with the right to maintain it for the purpose that you acquired it. This is why when you have power lines or communications lines, they can come in and cut your tree branches back. They are maintaining the easement. It's the same reason why, if you have public road running across the front of your property, the town can come in and dig up that edge where your property is covered by the public highway and put the sidewalk in or repair the roadway, et cetera. That is within the easement. And then there's a whole complicated case law about incidental sort of burdens that cross over from the easement line, such as there was a Supreme Court case about whether it was a taking when snow and salt from the roadway were deposited by snow plows on Route 7 onto someone's property. I'm not going to go into that, but there is a whole complicated case law around that, but you keep the easement. This whole case is about whether the legislature gave up one isolated property right in that bundle of rights while maintaining the easement. So, I can't tell you what the property right is worth. What I can tell you is that while we're waiting for the case to resolve and or possibly a future case to resolve, we won't know if the towns have to provide compensation for the maintenance right that we have put in here. And I just need you to have your eyes wide open about that when you make the decision about whether to keep it, take it out, play it, add intent language, whatever it is you do, you need to be aware of what the potential consequences are for the state and your constituents and municipalities, and then move forward with what you think is the best policy.
Okay, Tucker, thank you very much for joining us. I appreciate all your work on your schedule. Damien, thank you very much for all through that.